Hello everyone, welcome to Easy GST for You. I'm your host CA Girish Kulkarni, and today we are going to discuss another important aspect of GST law. Uh, the question is, can exporters claim refund of the unutilized input tax credit of compensation cess when they export goods on payment of IGST? So after years of confusion, the Gujarat High Court said yes, and now the Honorable Supreme Court has also dismissed the revenue's appeal, putting the matter to rest and giving a major relief to the exporters. So many exporters used coal as a input, which attracts compensation cess, but their final products like dyes, chemicals, aluminium, fabric do not attract cess. So when they exported such goods on payment of IGST, a quick key question which was under consideration is that can they claim a refund of unutilized input tax credit of the compensation cess that they paid on the procurement of coal. So the department of obviously relied upon the CBIC circular 45 by 2018 and 125 by 2019, which was the mega circular for refunds. So the refund of compensation cess of ITC is allowed only when the exports are made without payment of tax under letter of undertaking or bond, and not when the IGST is paid. So the exporters contended that cess paid on inputs like coal remains always unutilized since the exported goods are zero rated and the cess is not payable on them even if it is with payment of IGST. Hence, refund should be allowed under section 54(3) of the CGST Act, read with section 16 of the IGST Act and section 11 of the cess Act. So the Gujarat High Court agreed with the exporters' contention, and it held that the proviso to section 11(2) of the cess Act, which says that ITC of cess can only be used to pay cess, does not apply to the exports because cess is not payable on zero rated supplies. Therefore, unutilized input tax credit of cess on inputs like coal is refundable under section 54(3) of the CGST Act. The revenue challenged this Gujarat High Court judgment before the Honorable Supreme Court through the special leave petition which was filed, but the Supreme Court has dismissed the petition, thereby affirming the Gujarat High Court's decision. This means that the law is now settled in favor of the taxpayers. So now it is official. Exporters can claim refund of unutilized input tax credit of compensation cess when they export goods on payment of IGST, provided that those goods are not subject to cess. This judgment provides relief for industries using coal and other cess liable inputs. Refund claims which were wrongly rejected basis the circulars can now be reopened. There is a clear judicial finality. No further appeal is possible. So if your refund was denied earlier, citing these circulars, this judgment could change the situation. Follow us for practical guidance on how to file a refund claim post this Supreme Court ruling. Thank you so much. Stay tuned.